all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
Good evening. My name is Joe Sam Robinson. It's my pleasure to have with us tonight Mr. Buck Melton. Welcome, Buck.
Glad to be back.
We've had conversations on varying issues in the past, and really the thrust of our conversations have centered over our Constitution and its role as a defender of our individual rights as American citizens, and just how that plays out in our contemporary political landscape. So, in using that as a springboard for tonight's conversation, possibly we could discuss a little bit about the government's war powers abilities. I guess I would say that. I mean, the Constitution gives everyone individual rights. The Bill of Rights are there, and then when the government and when the American people are in a war situation, those rights are weakened. Is that a fair statement?
That's a pretty good way of putting it. That a nation or a state has not only the right but the duty to protect its own existence. And if there is a great threat to existence, as there presumably is in wartime, then presumably other things can be put on the back burner. It's not a desirable state of things, but it's the way of the world.
So we've had in our history, we've had numerous times that the Bill of Rights, our constitutional privileges have been, I guess, abridged by the government attempting to fight a war and protect its citizens. Is that a fair statement?
Yes, the most famous times are probably the Civil War and World War II, with World War I coming in there probably as a fairly close second. And then, of course, this new world of terrorism that we're in, when wars are not declared,
yes,
but they're fought for years and years and years,
yes,
and there's never a clear end. And that's a very dangerous situation.
Now, maybe since you're a constitutional scholar, maybe we could bounce the basketball in that direction a little bit. Most of the war, well, not all the wars in the 19th century were declared wars. There were occasional incursions in the Mediterranean or in the Caribbean. Different things have happened, but in general, major conflicts were declared wars. Is that a fair statement?
For the most part. I mean, and you did bring up that it's important to keep in mind that there are declared wars, but there are also states of war that are not legally declared. The Tripoli pirates, the undeclared
yes,
naval war with France, numerous interventions in the Caribbean
yes,
after the canal zone was grabbed. But probably one of the more famous undeclared wars was Vietnam.
Yes.
And of course that brought a lot of civil liberties to the fore as well, and we're still living in the shadow of that.
Well, just going through the 19th century, the Supreme Court really, there were cases that came before the Supreme Court. Here is, let's say you're fighting the Civil War, you're a captured Confederate agent, and whatever, your rights are being abridged. Copperhead in Indiana, they're going to, freedom of the press won't work as well. I mean,
yes,
comments
yes,
about it, the Supreme Court said okay.
Yes, Clement Vallandigham is the best
Yes,
example
yes,
of that. I think he may have been Ohio, you're right, he may have been in
I think
Indiana.
It was Indiana.
He was a
I think
Copperhead.
he was a Hoosier, right?
Yes. And if I remember correctly, he had actually been a member of Congress. He was no longer a member of Congress.
Yes.
And he was stirring up so much trouble that Lincoln allowed the military simply to take him into custody.
Yes.
And if there was any trial at all, it was by a military commission. It was
Yes,
not by what we call an Article III court.
Yes.
I think it ended up with Lincoln finally throwing him back into the Confederacy.
Yes,
but,
yes.
But it was there was a situation there where habeas corpus was simply not respected.
Yes.
That they were going to keep him in jail regardless of any proof of wrongdoing or
yes,
even allegation of wrongdoing.
Now, it's true enough that if I can understand this correctly, the Supreme Court said okay to this in a state of national emergency. But is there anything in the Constitution that says when there's a state of crisis, all the Bill of Rights is suspended? Is there anything in there that says that?
No, not really. The closest you come to that is what was involved in the Vallandigham case as well as in the Merriman case a couple of years earlier. That that the Constitution hints, without really setting out very clearly, that the writ of habeas corpus can be suspended when the public necessity may require it. Interestingly enough, it doesn't say who has the authority to do that suspending.
Yes.
And the reason why that's a big deal is that habeas corpus gives a defendant or someone who is detained or under arrest the right to know by what legal authority he is held. If you don't have a writ of habeas corpus, then the person can be arrested and held in jail indefinitely for dozens of years for any reason, for no reason at all.
Rather like Guantanamo. Is that a fair statement of that's exactly what's going on
and
there?
And that issue has been raised in the past.
So what I guess what I'm saying is that the Constitution did not really, a fair reading of the Constitution, impinging on the Bill of Rights, it's rather shaky. There's not a real place in the Constitution it can be pointed to in a fair reading that says, okay, now we're going to, this is what happens when all these rights are suspended. We do this, we do that, we do this. So this has been sort of manufactured out of a national necessity by the courts. Is that a fair statement?
Yes. The idea of martial law, once again, there's no provision in the Constitution other than the habeas corpus suspension. There's no provision that says, here's how you declare martial law.
Yes.
Here's how it takes place. The courts have said pretty clearly martial law just happens. It happens due to circumstance when the civilian order is simply broken down.
Now, Bucky, I'll just bring this up. I guess it's a fair thing to say. Is that some of the states have riot acts, do they not? Because I can remember as a young boy in medical school, the Kent State, in Charlottesville, the Virginia State Riot Act was read and martial law declared by the state of Virginia on the campus of the University of Virginia. So cannot the states declare martial law? They have authority to do things like that.
Yes,
and governors do that sometimes.
Yes, once again, and it's possible for the federal government to declare martial law as well. But for instance, I think it would be a very hard stretch to say that either the state of Georgia or the federal government could come in here right now while we're talking and say, there's a national emergency, I'm declaring martial law, the First Amendment no longer applies, I'm shutting you down. It has to be very patent, very obvious that conditions warrant it, like a huge crowd of unruly people who are destroying a campus
or riots
in
Los Angeles or wherever. Sometimes state of martial law is declared after a hurricane possibly, or looting, or Katrina, whatever, these things happen.
Yes.
Now, do the courts, just looking, I'm sort of moving along here, but have the courts attempted to restrict this abrogation of the Bill of Rights for emergencies? If someone said, well, look, you declared martial law for no reason at all, whatever, I'm just sitting in my house, people came in and threw me in jail for 6 months, and I mean, why did you do it? There was no real... And the courts attempted to limit this suspension of the Bill of Rights.
The courts have generally stood back and let it happen, as in the Vallandigham case. In the Merriman case that took place in 1861, there was a case of suspension of habeas corpus that Abraham Lincoln was afraid that Maryland was going to secede, which would have meant that Washington was surrounded by Confederate territory. So he simply ordered the general in command of troops in Baltimore and Annapolis to arrest these secessionist members of the Maryland legislature. One of them was John Merriman, and you had federal officers, federal soldiers, simply throw him in jail. Chief Justice Roger Taney,
who was a Confederate type.
He was a Marylander, so he tended to be somewhat sympathetic to the plight of the South. Was furious and said this can't be done, but he was writing as a circuit judge. It never made it to the Supreme Court. In the case of Duncan versus Kahanamoku in World War II, when Hawaii was under martial law for a couple of years because there was a genuine fear that the Japanese may have invaded, the courts sided with that. And allowed civilians to be tried by military courts. But interestingly enough, after both the Civil War and World War II, after the war was over, after the danger was over, then the court came out in a couple of cases with very strong denunciations
Yes.
of excessive use of martial law.
Yes.
So,
And I guess what I'm sort of trying to make the point is that in a declared war, things are a lot clearer.
yes.
And so when we've had we've declared war, everything gets pretty clear. I think most Americans can understand that the world is in danger, there's an invading army coming, the shell fire is taking place, we have to fight a war.
Yes.
And that's pretty accepted, and the courts sort of go along with that. And now you mentioned there's some repentance on the part of the courts. Later they repented.
Yes, yes.
After the war had been won. Can you name?
Exactly.
You were mentioning some of those cases.
The Milligan decision is probably the most famous one. Ex parte Milligan in 1866. Mississippi versus Johnson, Georgia versus Stanton, that tried to put a very strong break on this, that said you can't just throw a civilian in the jail or try him by military commission if there's a regular Article III district court just down the block that's operating and open for business. But of course, it's probably calculated that the courts waited until the danger was over to say that. Because there's always a danger that the courts could simply be ignored, as Taney was ignored in 1861.
Now, really, the last time the nation really declared war, where things are a little more black and white, was in 1941. And so the different there's been and much bloodshed, and many people have died, and we've fought very expensive wars. That's the word for them. Lots of terrific destruction. And the Constitution did not really, if I could imagine and say that, they didn't imagine this kind of thing taking place. It's rather clearly stated about a declaration of war, how that takes place in the Constitution.
Yes. Well, once again, we don't want to push that too far, because the court was pretty clear as early as 1798, 1799, that there is a difference between a declared war and an undeclared war, and yet they are both states of war. The big case there was the case of Bass versus Tingey. It involved the seizure of someone's ship during the undeclared naval war with France. He tried to claim that that was an illegal seizure because there was no declared war, and the court said, yes, the war wasn't declared, but it was still a war. Unfortunately, that is injurious to civil liberties, because it means that we can have the effects of war without there being a declared
Now, what
war.
I'm getting at, I guess, is this, and we've sort of talked about this before. The Constitution basically is just a simple reading of the Constitution. You would say, well, look, this is there's a way to declare war, and if the conflicts really the framers of the Constitution envisioned, conflicts would require a declaration of war, and the courts have basically, we said, it's so hard to change the Constitution or respond to national emergencies. The courts have fashioned out kind of a sub rosa Constitution, where they're just saying, this is what we're going to do, this is what we're not going to do, and it's independent in many ways of the actual language of the Constitution. Is that a fair statement, or is that too strong?
It may be a bit too strong. Once again, there are an aggregate of powers that are collectively known as the war powers. The Congress has the power to declare war. The Congress has the power to make military appropriations. The President is the commander-in-chief. There is a power to suspend habeas corpus. So all these things together do suggest that one or another branch can take certain measures in prosecution of the war.
So I guess I'm continuing to pushing the point a little bit. So a major big conflict, everyone can see, well, whatever has to be done to prosecute the war has to be done. In softer circumstances, where the way the country stumbles into things, there's not a clear demarcation of that. And it's possible to resist or not want to go along with this vaguely stated ambition, if you could say that. And then the government will say, well, we're in a state of war, although it's an undeclared war, and therefore we're going to abrogate your liberties. We have the power to do this to you and that to you, and if you resist, something bad will happen. And I think the sort of the 20th century, in many ways, reflects some of that conflict. The Pentagon Papers. I mean, we're right now we have this undeclared war, but the Vietnam War. People that were resisting in the Vietnam War were considered, you could say it mildly, traitors or any action that diminish the ability to prosecute and win the conflict in Southeast Asia came close to being construed as treason in some circles.
Yes.
Is it? And can you talk about that?
Yeah, I think it probably started, and Vietnam is an excellent example of that, and Vietnam also shows how it can implicate domestic security as Watergate merged into Vietnam merged into Watergate. Probably the first big step was taken with Korea when Truman, on his own initiative, President Truman ordered troops into Korea. Presidents had ordered troops into combat before that, but this was a major war. It was a conventional war. It was a war in the atomic age when you're dealing with playing with fire.
Right. And
the courts showed some restraint. It exercised some restraint on the president. But then when you get to Vietnam, you had congressional authorization in Vietnam. You had the Gulf of Tonkin resolution.
It was a very kind of strange 1964 resolution, yes.
Yes. And I think that between Gulf of Tonkin and some of the enabling resolutions in Gulf War I and Gulf War II, you see Congress abrogating its authority to declare war.
Yes.
It's doing it for all the wrong reasons because Congress has to go up for re-election.
Yes.
They want to let the president hold the bag on that.
Right. Yes.
And that combined with the new nature of asynchronous warfare with terrorists going after civilian targets is a very dangerous recipe for civil liberties.
So just taking the situation to our present set of circumstances, we have these, we all of Americans know the history of the past decade or so, 9/11, all the terrible things happened, and the Patriot Act, and the powers that gives to the government to do things to prosecute an undeclared war that's seemingly endless, a war that's seemingly endless. And no one can imagine that the tension that's out there is going to go away. I mean, people are going to presumably commit random acts of terror. They're going to blow up the Boston Marathon. They're going to shoot people if they get a chance. Then it seems to be that we're going to live with that in this century.
Well, it's a war of ideology, not a war of territory. It was very clear when we beat the Germans. We marched into Berlin. It was very clear when we'd beaten the Japanese. You can never have that certainty in a war of terrorism. It's designed not to be able to be subject to that test.
So now we get into a question as we're in this situation. What powers does the government have right now, and how much power should the government have to prosecute this war? And could the powers the government has received, could they be used for sheer political purposes? So in other words, if we're in a state of war, it's a vague, hazy war, it's uncharted territory, the government has huge amounts of power, and the government could use those powers not so much to prosecute the war, but to preserve their political power against their political opponents.
Well, we certainly saw this in Watergate with Pentagon Papers and Daniel Ellsberg, who was a civilian Pentagon employee, DOD employee. And at one point, Nixon had, I guess it was the plumbers or somebody else, his secret spy organization, break into the office of Ellsberg's psychiatrist in order to get dirt on Ellsberg and discredit him. So that's a classic example of what you're talking about.
So. But I guess I would say now we have a situation where the government, we have stories out there about what the government may or may not be doing, and it is possible to use this aggregation of power to, we have examples in the different ways the government is going to do things, but they could take records, they could do this, they could do that, they could not allow, I guess, entry into particular subject matter the government says is a national security measure. You have any thoughts about that, about what the government how this might be going on right now? Or
well, it could certainly be used for partisan purposes. I myself, based on what I know, I'm not seeing anything that is particularly partisan at this point. I am seeing a general chilling of civil liberties. And I think one of the things that's driven this home is that it's pretty clear that taken as a whole, the American journalist media establishment has always tended somewhat to the left.
Yes, yes.
And they have tended to be fairly lenient to the current administration. I think that the worm has turned with the Department of Justice subpoenas of AP, and the fact that apparently that Eric Holder went forum shopping
Yes.
to find a judge who would grant that subpoena after being turned down 2 or 3 times. You have noticed, I have noticed certainly a definite cooling in tone
Yes.
of the national media towards the Obama administration.
Yes.
And I don't think that was strictly partisan, because I
Yes.
think he largely had the press on his side.
Yes.
But what happens now that the press is tending a little bit in the other direction? Might we see
Yes.
more of this?
Yes.
So-
Well, I guess, I mean, we'd like to imagine the government is going to prosecute this in a neutral, even-handed way.
Yes.
And maybe they will, or maybe they are. But because we have this veil of secrecy over everything, it raises substantial suspicions.
Yes.
And one of the great opponents of the Obama administration would be Fox, the Fox News Channel, and so rightly or wrongly, one of their guys, I guess they were attempting to at least see what he was up to.
Yes.
Now, and apparently there's substantial, maybe we could just go through that whole arrangement as to how the Attorney General forum shops in order to cast a net on a particular group, and maybe to chill their inquiry into general issues that are not only foreign affairs but also political issues. I mean, his political opponents are checking on things, and I mean, I'll just give those guys a big nip, and that'll quiet them down. Any
Yes.
comments about that?
Well, I'm not seeing that happen yet, and if that's what they were trying to do, it has certainly backfired
not
against
work,
them.
did it?
Yes,
No.
it worked very. They overextended themselves.
Yes, yes.
But the idea of forum shopping is, I believe that this took place in New York, probably in New York City.
Yes.
There are a number of federal district judges in New York City. You can keep on approaching judges with this request until you find one that
Yes.
that is willing to grant the subpoena. That's the idea of forum shopping, or
Yes.
or one idea of forum shopping. If you look at the current Verizon issue, there is a federal district court known as the federal, I forget what it stands for, the Foreign Intelligence Surveillance Act, I believe is what it means. It's abbreviated FISA. It's a top secret court, essentially. And this means many different things. First of all, most people don't even realize it exists.
I might be one of them.
Yes. Secondly, it is an ex parte court. It means that the person being surveilled, the person being investigated, not only has no representation in that court, he does not have any idea that there is an investigation requiring judicial oversight. All of the lawyers and judges, all of the judges on that court, and all of the lawyers who practice before that court have secret clearances, and everything is conducted, to my knowledge, that's top secret. And it was the FBI attorneys who went before the FISA court and got the court to issue this subpoena to Verizon, as well as a gag order saying you will turn all of this data over to us. I don't know how this order got out. It has been gotten out somehow. I think the Guardian in the UK has got it. I've read it. It's a 4-page finding that under the Patriot Act and under a federal executive order, this sort of surveillance and this sort of subpoena is acceptable. And like I say, no one's there to challenge it when it's issued.
Now, so this court, is this a common part of our legal system? This is a reminiscent of the Star Chamber, isn't it? And maybe you could say what the Star Chamber was.
Yes, it's not quite like Star Chamber. They served different functions, but in terms of lack of supervision and a seeming arbitrary to it, it does seem like that. Star Chamber was a medieval court in England. It was what was termed an extraordinary court of equity. And it's thought to be called Star Chamber because there was a large star painted on the ceiling. And it was the king's personal court. And if you could not get justice in any other court in the realm, in a court of law, then you could take your case directly before the king. The problem is that the king could do anything he wanted in that court
Yes.
without any sort of supervision of the law. The Magna Carta in the 1200s,
Yes.
the whole point of Magna Carta said that the king himself has to obey the law. The king
Yes,
is below
yes,
the law.
yes.
That was not true in Star Chamber for the next few hundred years.
Yes.
And Star Chamber could even turn to torture to
Yes,
coerce you
yes,
to
yes.
give testimony.
So actually, I mean, we're getting into a point where we have undeclared war. We've got a lot of power out there. There's not any light of day on it. This power could go any direction it wants. And our forefathers, shall we say, Thomas Jefferson, John Adams, anyone that was around when the country was hatched out, would be appalled. I mean, I guess their first response would be, "You mean to tell me we've created a sort of a secret court that can do just about anything it wants in an undeclared war? Is there any limit or any appeal? Or suppose what about assassinations? Could the court say, we've decided to assassinate a couple of bad actors out there. We're going to have a drone fly over and blow them up." I mean, is there any limit to the power of this
Well,
court?
you would hope they wouldn't do that, and they would. The FISA court is not over the Constitution. It has to abide by the Constitution as well. But as Charles Evans Hughes, a later Chief Justice, said in 1909, the Constitution is what the justices say it is. So you would hope that these judges and that these officers of the court would feel sufficiently constrained by the rule of law not to do that. But lawyers are paid in order to be able to justify things that are sometimes seemingly not justifiable by logic. So that's a scary point. You mentioned Thomas Jefferson and John Adams. One of the major complaints of the revolutionaries by 1774, 1775 is that certain criminals were being deported to England to stand trial there in order to make sure there were no sympathetic jurors hearing their case to issue essentially a jury nullification. So this is not that far removed from that.
Well, Buck, we're going to continue our conversation at another time, but I think we've had a pretty interesting interchange tonight. So thank you for
Enjoyed
coming.
it. Thank you.
Thank you.